Contracts form the backbone of our legal and business world, but not everyone can enter into a binding agreement. Today, we're exploring the essential requirements for competent parties in a contract. Contractual capacity is the legal ability to enter into a binding agreement. The law presumes that everyone has this capacity unless proven otherwise. However, certain groups may lack the ability to form valid contracts, making their agreements either void or voidable. There are several types of contractual capacity, each with its own impact on agreements. Age restrictions, mental health conditions, and even temporary states like intoxication can affect a person's ability to contract. When capacity is in question, contracts are usually voidable, meaning they can be legally canceled, typically by the party lacking capacity. So, who exactly is considered a competent party? Generally, it's someone of legal age, with the mental capacity to understand they're entering into a legally enforceable agreement. This excludes minors, those under the influence of alcohol or drugs, and individuals with certain mental illnesses. Let's look at minors first. In most states, the age of contractual competence is 18. Minors can usually disaffirm or avoid ordinary contracts before reaching the age of majority and for a reasonable time afterward. However, there are exceptions. For instance, minors often can't back out of contracts involving real estate sales, loans, or their own businesses. What about people under the influence of alcohol or drugs? Contracts made in this state may be voidable, but only under specific circumstances. If the other party was responsible for the intoxication or knew about the incapacity, the contract could be disaffirmed once the person is sober. However, there's a limited time frame for this action. Mental illness presents another complex scenario. Agreements made with a person declared legally insane by a court are considered void. For those with mental illness not declared legally insane, contracts are voidable if the disability can be proven. In both cases, if the person later understands what they did, they may choose to disaffirm or ratify the contract. When dealing with entities like corporations or estates, it's crucial to verify the authority of the signing parties. This might involve checking corporate resolutions, power of attorney documents, or court-appointed guardianship papers. In conclusion, understanding the requirements for competent parties is essential in contract law. It protects vulnerable individuals while ensuring the integrity of agreements. Remember, contractual capacity is presumed unless proven otherwise, but it's always wise to verify when in doubt. By keeping these principles in mind, we can navigate the complex world of contracts with greater confidence and security.